Assalamualaikum and hi, my name is Umi Shwatujana with number matrix 066475. Today, I'm going to present to you one of the topics in LLB 20903 Family Law subject, which is requirements of valid marriage. In this topic, we will be discussing the requirements of valid marriage under the Law Reform Marriage and Divorce Act 1976 and factors that may vitiate the validity of marriage. There are several requirements of a valid marriage, which are age, consent of parent or guardian, not within prohibited relationship, avoidance of marriage by prior existing marriage, consent of parties, ways of solemnization of marriage, and procedures and formalities. Firstly, for the requirements of age in Section 10 LRA 1976 of male must attain 18 years old and female must attain 16 years old. If there are minor not attain the age as mentioned in Section 10 with license from the Chief Minister, it means that a male that is under 18 years and female under 16 years old can get married to each other unless there is a consent from the Chief Minister. This situation can be seen in the case of Hoi Song against Oi Peng Yong. Secondly, consent of parents or guardians. In Section 12, Clause 1 of LRA 1976, if the party is below 21 years old but above 18 years old, they must get a consent from the parent. Moreover, the consent must be in writing. Consent may be acquired either from the father or mother, or adopted father or mother, or from persons in local parentage, but the consent is not required if the parties has previously married. This can be referred to the case of Kanagalingam against Kanagaraja. Thirdly, not within a prohibited relationship. Consanguinity. Consanguinity is the prohibition of marriage due to relationship by being descended from the same family as provided in the Article 11 Clause 1 of LRA 1976. No person shall marry his grandparent, parent, child or grandchild, sister or brother, great aunt or great uncle, aunt or uncle, niece or nephew, great niece or great nephew. This is because to protect the sanctity of the marriage and integrity of the family. Fourth, avoidance of marriage by prior existing marriage. According to the LRA 1976, monogamous marriage is not recognized and will be void. Monogamous here is referring to a relationship with only one partner at a time rather than multiple partners. It can be seen in Section 5, 6 and 7 of LRA 1976 in the case of PP against Rajapan. Fifth, consent of parties. In Section 37 of LRA 1976, any person who used any force or threat shall be punished with an offence. So, in order to get married, both parties must give their consent. 6. Ways of solemnization of marriage. According to Section 26 of LRA 1976, a marriage may be solemnized by the register appointed under subsection 28 Clause 4 at the Malaysian Embassy, High Commission or Consulate in any country which has not notified the government of Malaysia of its objection to solemnization of marriage at such Malaysian Embassy, High Commission or Consulate. Lastly, procedures and formality. In Section 27 of LRA 1976, it must be registered pursuant to the law. Though registration is a compulsory process, it recognizes marriage solemnized under any laws, custom, religion prior to the introduction and application of the LRA 1976. In addition, there are also factors that may vitiate the validity of marriage, which are marriage is not registered under LRA, a marriage with the age under 18 and without consent of the parents, failure to obtain consent from both parties, and no written consent before the solemnization for future marriage under the age 21 years old.